Hi, and welcome to this presentation on online sales. My name is Paul Lugard. I'm a competition law partner with Baker Botts in Brussels, and I've been practicing competition law for some 20 years. When you say that, you realize you're not a young man anymore. But I spent a good part of my career in this field of the law, mostly as an in-house counsel for one of the European technology and consumer products companies, where distribution issues and online sales were obviously important. I am the chairperson of the ICC Commission on Competition and the vice chair for the Competition Commission of BIAC, which is the Business and Industry Advisory Council to the OECD. We are here at the Baker Botts office in Brussels. As you can see, the weather today is not that great. If you decide to visit our offices, I'm sure it will be much better. And actually, the weather in summer can actually be quite nice here in Brussels. So today we are speaking about online sales, and in particular how restraints on online sales are regulated under European competition law. And this is an important area for companies because increasingly, obviously, companies are distributing their products on the internet. Many branded good manufacturers have retailers that would like to do the same thing. Sometimes this leads to channel conflicts. So there is an increasing use of the internet for online sales, and this creates obviously a lot of issues. Now, the problem I think in this area is really that currently, specifically in Europe, there are radically different approaches between national competition agencies with regard to online sales. So we have a number of agencies that take a very, I would say, relaxed view on restraints on online sales, and there are agencies that are very critical on restrictions on the same sales, and this creates an issue. I mean, many companies would like to set up their European system, and that makes it, those diverging approaches make it very difficult to have a uniform system across all the European countries. So we'll discuss that a little bit in a few minutes. Now, before doing so, I would like to situate this topic in a wider context and briefly discuss a number of main trends that have occurred in the last 15 years or so in international competition law. And the first one is obviously the globalization of antitrust regimes. When I started as a young lawyer, there were 5 or 6 jurisdictions that were important, and obviously those were the European communities, Germany, the US, Canada, Brazil, and maybe Japan. And that has changed. In the last 15 years, there has been a massive expansion of competition regimes across the world, and the International Competition Network, the ICN, now has about 138 member agencies. There are merger control regimes in about 90 jurisdictions, and the only areas on a global basis where competition law has not really been accepted yet as a mechanism to regulate economic conduct are some parts of Africa and the Middle East. Now, the globalization of competition law makes it more complex for companies, especially in international merger cases, but also in other areas such as online sales. And for practitioners, it becomes in-house and external practitioners, I should say, it becomes increasingly complex to come up with a strategy and a compliance vision that works across all these jurisdictions. So that's the first main trend. Paradoxically, the immense increase of enforcement regimes and agencies has led to a significant fragmentation in enforcement policies, priority setting, substantive rules, and also in due process standards. So one could say that the ICN has been very successful in persuading countries to adopt a competition regime, but at the same time that organization has not yet been successful in bringing about convergence and uniformity, or at least a level playing field, if you wish, across countries. And there are still a number of very important differences between important jurisdictions. And this applies to merger control, where some agencies would apply industrial policy. It applies to the area of vertical restraints and in many other areas. By the way, the ICN, as you may know, organizes on an annual basis conferences. This year the annual conference would be in Sydney, and the main special project, that has been chosen for this year, will deal with online sales. So this is a very important report that we're expecting in April of this year, and it would be very interesting to see how different agencies across the world apply their laws to online sales. So for those of you who are interested, the ICN special project report will be quite something to look forward to. Now, the third trend is diversification. And there have been many agencies lately, including the Korean Fair Trade Commission, the Dutch ACM, which is the agency of the country where I'm coming from, the Netherlands, the Danish Competition Agency, and other agencies diversify their mandate. So they become responsible for a wider portfolio of activities. They not only apply competition law, but also consumer law in some cases, and are responsible for regulated sectors like telecom. And this potentially increases the potential for a less rigorous application of competition law. Agencies are inclined in some cases to intervene in a specific market, and maybe not through the application of competition law in the traditional sense, but with other means, and that becomes less predictable in many ways, and I think that's something for companies to keep in mind. The fourth trend is enhanced interagency cooperation. There are many more agencies, but they also increasingly cooperate with each other. And this not only happens within the ECN, the European Competition Network, but also among agencies on different continents. And for those of you who are interested in OECD work, only last year the OECD has adopted a recommendation on the exchange of confidential information. And interestingly, that recommendation includes the possibility that agencies exchange confidential business information without the specific consent of the parties involved. So you would expect, as we all know, that agencies ask for a waiver for companies to allow the agency to exchange information with other agencies, but the recommendation opens the possibility that this happens without the consent of the parties, and that's an important thing for companies as well. And then the fifth trend that is important is litigation. There is increasingly litigation. The European Commission has been very active in promoting private litigation, follow-on litigation, and a number of European countries have been very active in that field as well. So what we see mostly in cartel cases is more litigation in this area. So that's very briefly a number of key trends, and I would now like to move to the subject of today, which is again online sales. Now, the internet has become a very important channel to market. not only for traditional products but also for new products. So in many ways, the internet has given rise to new products and services being developed. Nowadays we have iTunes, so many of the traditional record shops have disappeared. There are also many new entrants such as eBay and Alibaba that offer services that are very specific to the internet. There are price comparison sites, there are online hotel booking platforms. There are companies that facilitate online services such as eBay, such as PayPal, I should mention. And there are very significant efficiencies, both in terms of price reductions, but also in terms of dynamic efficiencies for consumers. I don't think that anyone would disagree with that position. Internet sales are still minor compared to offline sales, but nevertheless account for 5 to 10% of total commerce, which makes it actually quite a large number in absolute terms. Interestingly enough, consumers in Europe nowadays mostly purchase from suppliers that are established in their own country. So you would expect that online sales are by definition international, but in many cases these online sales are actually of a national nature. Now, how are these type of activities regulated in Europe? The distribution arrangements that cover these online sales are in many ways traditional distribution agreements, and that makes them a vertical agreement. And for vertical agreements, we have a group exemption regulation in Europe, Regulation 330 of 2010, which provides a general framework for vertical restraints, and that also applies to these distribution agreements that relate to online sales. But I should mention that it is a very general regulation and there are no specific clauses and provisions on online sales. The second legislative piece that is important are the guidelines for vertical restraints. Those apply to vertical agreements that are not benefiting from the group exemption. And there's a bit more specificity in those guidelines on internet sales and restraints on internet sales. And I'm going to speak a little bit about paragraph 54, which provides for rules on quality criteria for internet sites. A supplier can require from its distributor that it applies certain quality standards for the site that it wishes to put in place. And there is another paragraph which is very important in practical terms. That's paragraph 56, which essentially states that if you involve a reseller, then A, you cannot prevent that reseller from selling on the internet, but you can, in the framework of a selective distribution, apply equivalent norms that you would apply as the ones that you would apply in relation to offline, so brick and mortar shops. And paragraph 56 is very important because that embodies the equivalence notion, which in practical terms sometimes creates issues. Now, there are two preliminary questions. One is, should national agencies actually become involved with online sales? Now, we've just seen that many of these online sales are still national, which would militate in favor of national agencies becoming involved. But let's now assume that, the internet is an international phenomenon, and then you can legitimately ask yourself, well, should national agencies be allowed to take positions that have an impact across European, in our case, European countries? So that's I would say, a priority issue for agencies. And then there is a more fundamental issue, which is that most online restraints or restraints on online sales are intra-brand restraints. So they only restrain the dealer in selling online. They don't have a direct impact on interbrand competition, which is the most important source of competition. Now, if that's true, then the question is, should competition agencies be involved in intra-brand restraints as far as they relate to online sales? So, very briefly, how can internet sales affect the competitive analysis of transactions? Well, it can have an impact, internet sales can have an impact on market power, potentially an impact on market definition. Markets can be wider, markets can be smaller, in the sense that there may be a specific market for online sales in some cases. There may be very specific negative effects that are specific to online sales. For instance, online sales may make collusion more likely in specific circumstances. And at the same time, there may be internet or online specific efficiencies that you wouldn't find in offline sales. Now, what are the controversial subjects these days? And again, I'm looking primarily to the EU. Well, first, there are issues surrounding the prohibition imposed on resellers to use platforms. In many cases, branded good manufacturers do not want their resellers to sell their products through eBay or Amazon, and this has given rise to quite a hefty debate in Europe. That's one area. The second area is price parity clauses, and those are, well, you could probably describe them as most favored nation clauses that owners of platforms would impose on companies that would sell their services through the platform, and essentially would tell those service providers that the price at which they offer the product on the platform should be the best price available. So in other words, if a hotel would decide to use a platform, an internet platform, to offer its rooms, then that platform may request that hotel chain to not apply better rates on other platforms or apply better rates itself. And there has been, again, quite a debate on how those price parity clauses would affect interbrand and also intra-brand competition. So those are two main problematic areas. Let's now take a step back and let's look at some cases, and that would give you a sense of what's going on in Europe. So I would think that there are, broadly speaking, three categories of cases that involve online restraints. And the first category is the category of what I would call conventional problems. Problems that you would also find in the offline world, and those may relate to intra-brand competition and inter-brand competition. So conventional problems involving intra-brand competition are vertical price fixing, resale price maintenance. There have been a couple of cases in Germany that involved this restraint. So typically that means that a supplier would impose a restraint on its reseller not to sell the products at a lower price than the price prescribed or at a fixed price, your typical resale price maintenance arrangement. And those cases are SIBA, Phonak and Walla. Those are the most important cases that have been decided upon by the Bundeskartellamt. And there the rule is very simple. You are not allowed to engage in resale price maintenance, neither in the offline world nor in the online world. Second category, or second subcategory I should say, is differential pricing, whereby resellers would be discouraged from selling over the internet, for example, because the supplier would require that the dealer would pay a higher price for the products that it sells online. And again, that has been struck down by the Bundeskartellamt. And then there are conventional problems that relate to inter-brand competition. And the best example there is, I think, the e-books case, which has been decided by the EU Commission, and that involved the online sale of books. And there, I think the driving factor has been how the agency arrangements between Apple and the publishers would affect inter-brand competition. It's a really very interesting case. Now, so that's the first conventional problems category. Then the second category is in a way also conventional, but more specifically relates to selective distribution. And selective distribution is a form of distribution that is very specific to the European Union. Essentially, it is a form of distribution that was traditionally applied by suppliers of luxury products and fashion, so perfumes, fashion, those type of products. And selective distribution typically allows a supplier to select its distributors, its resellers, according to specified criteria. There's a difference between qualitative selective distribution and quantitative selective distribution. But the essence is that once you set up a selective distribution, you are allowed to stop sales by those selected approved resellers to non-approved resellers. So in a way it's a closed system, and typically approved resellers can only sell to other approved resellers or to end users. That's the essence of selective distribution here in Europe. But selective distribution has also given rise to a number of online sale debates. One thing is that, well, the question is, could you prevent dealers that are part of a selective distribution from selling over the internet? And the question is no. For all practical purposes, the question is no. This was raised in the Pierre Faber case, where the Court of Justice said, well, unless there is a very exceptional justification, dealers must be permitted to sell over the internet, and the nature of the product would normally not be such that you can prevent them from doing so. But selective distribution has also raised a number of other issues, and I just mentioned paragraph 54, which provides rules for the quality of the internet site that selective distributors and other distributors, by the way, can be made to apply, and the equivalence principle that is included in paragraph 56. So if you apply specific rules and criteria for offline sales, then you cannot apply non-equivalent rules for online sales. That's the essence, but the practical application is very complex in some cases. Within the context of selective distribution, there has been one specific issue that has attracted a lot of attention, and that is the prohibition to sell on third-party platforms, such as eBay and Amazon. So these are cases where the supplier wanted the selected, approved retailers not to sell over those third-party platforms. And most of you would know the Christian Dior case in France, which has been looked at by the Conseil de la Concurrence, and the Adidas and Essex cases in Germany. And there I think we see a very important divergence. And particularly the Bundeskartellamt has been very, very critical with regard to these third-party platform prohibitions, and essentially says, well, we don't want resellers to be prevented from selling over third-party platforms. There is a real debate on whether this is a resale restraint, which would turn it into a hardcore restraint under Article 4 of the Regulation 330/2010, or whether a platform provision, an obligation not to sell over a third-party platform, could be qualified as a quality norm within the meaning of the guidelines on vertical restraints. That is essentially the issue. I have a personal opinion on that one, but I'm not going to share that with you. But there is a debate, and there are positions, there are arguments that go either way. I do believe, by the way, that the Bundeskartellamt is taking a extreme position in this matter. I happen to be present at a meeting of the Dutch Association for Competition Lawyers, and there I think the chairman of the Bundeskartellamt, Andreas Mund, explained how the Bundeskartellamt is dealing with these matters, and that is clearly in contrast with, for instance, how the Dutch agency treats these restraints. I think the Dutch agency would be more inclined to treat these third-party platform provisions as quality norms and perhaps not as a restraint, and certainly not as a hardcore restraint. I would believe that there is really some room for the EU Commission to bring some convergence in this area. What is at stake here is the application of the guidelines on vertical restraints and how different agencies apply those guidelines. And there I think the EU Commission should ensure that there is a minimum level of uniformity. Now let me briefly say something about the price parity clauses. And this is an issue that has come up particularly in the e-books case, in hotel reservation services, again a matter that was looked at by the Bundeskartellamt, and in the booking.com cases that have been looked at by the OFT, and again a whole lot of other agencies. And the issue is here, well, if an owner of a platform would require from a company that offers the services or goods on that platform to offer the best price on that platform, would that necessarily restrain competition? And again, the Bundeskartellamt has taken a strict approach and tends to believe that this is a hardcore restraint. Why? Well, because it affects how other platforms, potentially competing platforms, can enter the market. I mean, you can imagine that if there is a well-established platform that requires a best price guarantee, then that would make it more complex for a smaller new entrant platform to enter the market, because that new platform would never be able to offer a better price than the large existing platform. So that's essentially is a very important issue. There's also an intra-brand component because the hotel chain or the other company that offers these services would not be able to offer a better price itself, or would not be able to allow its dealer to offer a better price. So it's a mix of an inter-brand and an intra-brand issue. Again, I think that this is something that the EU Commission should perhaps take up. There have been a number of agencies looking at this matter. There is no, I would say, overall comprehensive framework. It is something that has not been addressed at all in the vertical restraints guidelines. So this is clearly something that the Commission could and perhaps should take up. I'm going to leave you with maybe one or two final remarks, and one is that I believe that this is an area that is becoming increasingly important. It is a interesting sub-niche of European competition law. There's a lot of divergence here, and there is a clear task for the European Commission to critically look at these diverging approaches. That's one thing. The other thing is that I wanted to thank you very much for joining today, and I hope to see you soon in person. Thank you very much.